Okay, Assalamualaikum warahmatullahi wabarakatuh. We have come to the final part or part four of the recorded lecture for the topic nuisance. We have covered everything or we have discussed everything about the elements of public nuisance and private nuisance. So the last part of the lecture actually will focus on the parties or the local standby given. Who actually can sue or who can be sued. So we are going to start with who can be sued. So there are at least three parties who can be sued here or who can be the potential defendant. The first one, creator of the nuisance, the one who creates nuisance. The second one, occupiers of the land. And the third one, landlord. And in terms of who can sue, who can be the plaintiff, we covered indirectly when we discussed public and private nuisance actually. So we want to know who are the parties who can bring action for public nuisance as well as private nuisance. So let us start. Okay, now we start with who can be sued, who can be the potential defendant here. The first one is creator of the nuisance. It means any person who creates the nuisance, he can be sued. Whether or not that person is the occupier of the land at the time of the action, doesn't matter, so long he's the one who creates the nuisance here. So we have the case of the famous case of Stephen Pua Cheng Lun and Highland Properties. This is 2000 case. So the rule that we derived or extract here, the creator of the nuisance would be liable even if he is not the occupier or the owner of the neighboring land. He can still be liable for nuisance because he's the one who's responsible to create the nuisance. That one straightforward. Okay, another one is occupiers. Okay, what does it mean by occupiers here? Occupiers can be liable, okay, if they continue to allow nuisance. Okay, they are not the one who create, but they allow the nuisance or nuisances on their land, so they can be held liable, even if such nuisance were created by other parties, or even by their predecessors in title, or trespassers, or even third parties. So we have this case of common law. Sedley Denfield and O'Callaghan. Okay, this is 1940. In this case, House of Lords established a landmark principle regarding an occupier's liability for a nuisance created on their land, okay, by a third party or trespasser. They cannot simply say or plead, oh, we are not the one who created the nuisance, okay, it's created by third party, okay, somebody else, or created by trespasser. But because he allows the nuisance to exist or to happen, then they can be liable for nuisance. Okay, for landlord here, in what situation landlord can be liable here? Okay, landlord can be liable for nuisance if he has authorized the nuisance or where the landlord reserved the right to enter and repair the premises. He has the right to put a stop to the nuisance. That's why he can be liable. Example here, the case of Tetley and Chitty, this one 1986 common law. So council granted permission for a go-kart track on the council-owned land. So the land belonged to the council and they allow this activity. Okay, they give permission, they give license to this go-kart track. So it creates nuisance from that activity. So council was held liable for nuisance, especially for the noise, because go-kart, it produces lots of noise here, go-kart track. And then we have some other cases, other cases of who may be sued, okay, but there are some contrasting Court of Appeal authorities. We have the case of Hussein and Lancaster, or Lippiat and South Gloucestershire. Is all about who can be sued, who can be liable for nuisance here. Even the court, sometimes they give different decision. But basically, what you have to know, landlord can be liable actually. All right, for who can be the plaintiff, okay, for public nuisance, obviously we have discussed in the part one of our recorded lecture, okay, state or even public bodies, or exceptionally, the right given to individual who has suffered a special damage. For private nuisance, okay, who can sue or who can be the plaintiff? Owner of a land in exclusive possession, they are the one who possess the land exclusively, or even not the owner, but a tenant as well. Can have the right to sue. Or even a licensee, or a person who has proprietary or possessory interest in the land. Not the owner, not the tenant, but even, only merely licensee has the right, has the license, consent, permission to be on the land. So, to be in the building, on a premise, for example. Yes, they have the right to sue as well. So, all the above persons can sue, okay, either public or private nuisance here. So, we have all the cases to discuss. All right. Again, this is the issue of local standi. Okay, whether they have the right to sue or not. For Malone and Lasky, this is a very old case, 1907. Okay, the court was strict. Okay, in deciding this case, the plaintiff was the wife of a tenant. I mean, not the tenant, but only the wife of a tenant. So while she was using the laboratory, okay, the toilet, so a heavy iron cistern, okay, part of the things, okay, from the toilet, the picture there, okay, cistern fell on her head and it caused injuries. And why did it happen? This was due to vibrations, okay, from the defendant's neighboring power station, and it caused the cistern to become loose and eventually fell onto her. But the court held that for nuisance, okay, her claim failed because why? She doesn't have the sufficient local standard. She was merely the wife of a mere licensee, and she had no proprietary interest herself in the land. If it was the husband, okay, the real licensee, okay, the tenant, so the husband has the right. But for the wife or licensee, no right for nuisance here. So what do we learn from this case? Only a person who has a proprietary interest in the land affected by the nuisance will succeed in a claim. Okay, that's the law of nuisance, okay? But then, hold on, all right. So, what's the reason? What's the ratio of the decision? Court of Appeal held that plaintiff had no cause of action in nuisance. So this is the reason we might be wondering why. Why the why the plaintiff cannot succeed here. The court looked at two reasons here. The first one, lacks of proprietary interest. Just now, okay, we have discussed this one. Plaintiff was a mere licensee. Okay, she was not the owner of the land. And the court ruled that only a person with the right to the land, such as freeholder or tenant with exclusive possession, can bring claim. And then the court also highlight the nature of nuisance here. Okay, nuisance is a property tort, not a personal tort. Personal tort means negligence, okay, most of the time. So court, relates to negligence. So court emphasized that the tort of private nuisance is designed to protect property rights, okay, not to compensate for personal injuries. So I believe if she sued under negligence, then she might succeed here, okay. So because the plaintiff had no legal interest in the property itself, that's why she could not claim for interference with its enjoyment. So she's the wife. She's not the co-tenant whatsoever here, right? All right, let's discuss this case. This is quite recent compared to the earlier case. This is 1907. This is 1993. Okay. So the issue is whether those who have no proprietary rights on the land can sue. So the case is double K, Corazon Dijon, okay, and Bush, 1993. So plaintiff in this case, she was 18 year old, so a teenager. So she lived with her parents in the family home. So now she's asking for injunctions against defendant. So who was the defendant here? Ex-boyfriend, okay, her ex, who had taken to engaging, very annoying here, okay, harassment actually, had taken to engaging in a range of threatening and harassing behavior towards her. So now we will have to see, does she have a legal stand, local standard here, legal standing. So was there a legal basis for the court to make an order for injunction in relation to telephone calls came made to plaintiff at her parents' home? So the court held, the court agreed, okay, the court answered in affirmative, yes, there was, because why? Defendants conduct, okay, the non-stop harassing telephone calls here. Defendant's conduct amounted to a nuisance that if persistent, unwanted telephone calls can interfere with the ordinary enjoyment of the property. So this nature of call here, it affect the way that you want to enjoy the peacefulness of your property without any interference, any disturbance, any harassment here. That's why the court allowed the claim here. All right. And we have another case, but this one is from Canada. Okay, Canadian court, Motherwell and Motherwell. So again, it involved harassing telephone call. Wife of the homeowner, okay, was entitled to an injunction to prevent harassing telephone calls on the ground of private nuisance. So basically, the court, is, the court has consensus with regards to harassing telephone calls here. It is a nuisance actually. So, and in this case, what do we learn, or what's the ratio here? Category of who can sue was broadened by virtue of this case, 1976. Okay, a spouse who occupies the matrimonial home. So, in this situation, she has a sufficient interest in the property to sue in private nuisance, even though, okay, she's merely a wife. She's not the legal owner. Okay, only a wife. Okay, of the tenant or of the occupier here, but she can sue because it involves harassing telephone calls. So that's basically about the local standby, okay, where I mean who can sue, who can be sued here. All right. So now another part of the or the towards the ending of our lecture here, defenses. On top of general defenses, okay, the third box there you have other defenses, okay, necessity, as of third party or as of God. But for nuisance, we also have defense which is known as prescription, or the consent, okay, certain consent given, or even statutory authority. So these are all defenses which are available for defendant, okay, in the suit or claim pertaining to nuisance here. Okay, what does it mean by the word prescription here? A private nuisance that has continued, I mean, this is at common law, okay, for 20 years without interruption. I mean, it has been ongoing, okay, nobody ever complain or ever sue it or take the action in the court, all right? So it is a good defense, okay, 20 years, okay, without interruption. Defendant basically has to prove that the interference is an actionable nuisance for the entire 20-year period. I mean, in order for him to succeed in this defense. And plaintiff had allowed this interference to occur for 20 years. At the 21st year, for example, plaintiff decided to take action. So basically, he's being, I mean, it is a good defense for the defendant to I mean, to plead that, oh, there's no interruption. Okay, this nuisance has been ongoing for 20 years. So no interruption. So now you cannot take action after 20 years. You want to take action before 20 years. So this is the case, okay? The court allow a defendant to claim a legal right to continue a nuisance as he has been doing it openly and continuously for at least 20 years without objection. So that's the case stages and breachment. Uh, I mean, one is the confectionery owner and another one is doctor. So doctor built consulting room next to a confectionery workshop, okay, confectioner's workshop, which had been operating for over 20 years. Okay, meaning after 20 years now she wants to take action. So the court held that the prescriptive right began on the use of the room. I mean, it's too late for you to complain or to take action after 20 years. Okay, it's a good defense which is available to the defendant. Okay, for statutory authority, okay, I mean, whatever relevant statute here. If defendant's activity is authorized expressly or by necessary implication by a statute, so defendant can protect himself by saying, oh, this is under statutory authority. So defendant may rely on the defense of statutory authority. But then again, okay, there's a test, a relevant test here. Could the nuisance have been avoided through the exercise of reasonable care? So defendant need to prove. Okay, it will be for the defendant to show that the nuisance could not be avoided through the use of reasonable care. And what more, whatever his act here, his business, his activity is under, I mean, it is allowed by the statute. And then he has exercised reasonable care. Then he can use this as a defense. So this is the case. This is from Hong Kong. Okay, Hong Kong Law Report HKLR. Lam Yu Lam Yu Fong and AG of Hong Kong. This is 1987. So the Urban Council was held liable for the nuisance arising from the placement of a waste disposal container adjacent to plaintiff premises. I mean, you don't want this waste disposal to be nearby your area, kan? Because it will attract all the unnecessary animals or even insects, kan? All right. So the noise, smells, and mess created by the placement of the container could have been avoided. I mean, there's some other way of managing the things here, avoided by reasonable measures, okay, such as stepping up notices of prosecution against offender. First, there must be notices of illegal dumping, and then another way is to change the procedure whereby householders were required to bring refuse, okay, to bring their rubbish within minutes of the arrival of the collection, so that it won't attract all these unnecessary animal or pests or insect or flies whatsoever. I mean the way, okay, the collection methods of this garbage lah or waste. So, I mean, still, the council cannot argue, oh, actually, we are being authorized under statute. Because why? There should be some other way, reasonable means, okay, to avoid this nuisance. Of course, for other defenses, you can cross-refer to earlier part of your syllabus, okay, I mean, in your thoughts one, okay, we discuss all this general defenses, necessity as our third party and as I forgot. All right, the last two slide. Okay, this is just for knowledge purpose, okay, because defendant, okay, might try to argue under this point, but usually the court won't allow. So that's why it is under the subtopic ineffective defenses. So first, okay, can defendant argue, oh, plaintiff come to the nuisance, okay, the activity has been ongoing and suddenly you come and stay here, you come and build your house here, so you come to the nuisance. So coming to the nuisance is no defense, okay. It is no defense to prove that the plaintiff came to the news. It doesn't matter who comes earlier, who come later. So the case of Miller and Jackson, I mean, the one of the issues which were discussed, okay, in this case, does it matter that the cricket club was there first and the plaintiff moved to the nuisance later? So, and the court held that it is no defense to say the plaintiff moved to a place where the nuisance already existed. So the Millers, I mean, both the moment you become the owner, okay, landowner, so the Millers had the same rights to enjoy their property as any other landowner, even though they are the new landowner, doesn't matter, okay. And then another ineffective defenses, okay, public benefit, depending, okay, utility or public benefit. You cannot simply argue, oh, our activity here is for public benefit as a whole. I mean, the court will look into, okay, whether it is really a defense or not here. And also contribution of others. Okay, you cannot put the blame on others. You can say, oh, we are not the one, we are not the only one creating the nuisance. There are some other people who contribute to nuisance. So usually the court won't simply allow this kind of defense. Okay, last slide, okay, before we end our topic on nuisance here, remedies. So remedies for nuisance, I mean, similar to all other tortious action, okay, damages obviously, and most useful one or very important one, injunction. Because why? You want the nuisance or the harassment or whatever annoyance to stop. So you have to ask for a court injunction. So for damages, okay, compensation, so it is awarded for physical damage to property or even for economic loss that is resulted from the interference, okay, and as well can also ask for, but usually the amount is not much, okay, for mere disturbance and inconvenience, which is also recoverable. So these are all for the topic nuisance, okay, right, that's all. So I stop share. All right, so till we meet again for some other topic later. Okay, Assalamualaikum warahmatullahi wabarakatuh.